was tied with maybe perhaps Justice Kagan for being in the majority the next fewest times. So because of some decisions that were not necessarily aligned with business interests in the voting rights case, there were actually quite a number of decisions this term that did not come down with the anticipated alignment, despite starting with the big fish that Heritage has been talking about today. They're not necessarily indicative of the alignment of all of the cases this term. So Students for Fair Admissions, I mean, this was obviously a very highly anticipated case, perhaps the biggest constitutional law case of this term in comparison to Dobbs, which was the big decision last term that everybody was waiting for along with Bruin. And Students for Fair Admission dealt with affirmative action, and I think a few interesting issues about the decision. I mean, the facts of the holding, I think most people know, right? The Harvard and UNC programs were challenged either or both for violating the Equal Protection Clause because of discriminating or making distinctions on the basis of racial and ethnic backgrounds, but also for violating statutory requirements in Title VI that prohibit discrimination for schools receiving federal funds. One interesting thing about the cases, they were originally joined together, but they were argued then separately with two separate attorneys because of the purposes of Justice Jackson recusing from the Harvard decision, although nonetheless, when the opinion came down, I guess because the justices were arguably deciding it more broadly or more across the board than perhaps they could have, they issued one decision to cover both cases as opposed to hinging more on the specific facts of the Harvard program or the specific facts of the UNC program. They really did take on more full-throated analysis of the constitutionality of racial preferences in admissions in general, and so because of that, we're able to do that in one decision. Interestingly, the recusal then was carried out essentially through a notation at the end of the opinion that Justice Jackson was not part of the deliberations in the Harvard case. She did write a separate dissent, I guess presumably just on UNC. But in any case, with the decisions, we did have Justice Thomas writing separately as well, Justice Kavanaugh writing separately. Justice Kavanaugh did what he is developing now a practice of doing, which was to describe how the decision, even though it might appear to be overruling precedent, since the court in the past had not found certain affirmative action programs to be inconsistent with the Constitution, he was writing to flag how he thinks that this decision is sort of in line with the court's past decisions, trying to, I think, dial down the temperature a little bit, make it seem more modest. Justice Thomas took his well-worn approach of, well-trained approach of describing how the holding of the court, even though the court's majority opinion was not principally describing originalism, how the holding of the case was consistent with the original understanding of the 14th Amendment. And then how did we get to the 6-justice majority? Well, essentially, the holding basically said that racial preferences cannot be used as racial preferences in admissions, that making these kinds of racial distinctions is a violation of the Equal Protection Clause. I mean, the court, I suppose, I mean, really didn't leave much room, and perhaps the panelists will disagree with me, but didn't really leave much room, I don't think, for using racial preferences as preferences in general. So in that sense, it arguably was quite broad. How did all 6 justices get there? Well, I think jurisprudentially, each of them tend to have a more textual approach to the Constitution, and so they're seeing the racial preferences as violating the equal protection provisions in the 14th Amendment. But also this case was interesting, I think, in how it was argued, because it took a look at actually not just the benefit being given to one racial group or set of racial groups under the Constitution or the distinction here, but really unpacked in an evidentiary manner in the lower courts stereotypes against Asian Americans. And so I think the context perhaps of looking specifically at the harms to some groups and not just the benefits to others perhaps gave context that allowed everybody to land where they did here. And just one final point, I think there's one interesting distinction between from this decision with the Dobbs decision last year, where it was really 5-1-3, 6 supporting the judgment, but the Chief Justice wrote separately because he did not want to sign on to Roe in case he'd been overruled. Here, technically, the majority opinion doesn't expressly speak of overruling any past precedent. Perhaps that is one reason why the Chief felt comfortable joining it, and being part of the majority opinion, he was then able to assign it to himself to write. How did he get Justice Thomas? Well, Justice Thomas wrote separately to say essentially the majority opinion really did overrule precedent. And so I just wonder, it's interesting to think about the dynamics behind the scenes. Of course, we don't know. But did the justices avoiding the express statement of overruling, in contrast to the Dobbs decision, make the chief feel more comfortable writing it as the chief? Would folks like Justice Thomas, who take more of a purist view, have negotiated and gotten stronger statements in the opinion to feel comfortable signing it? How did they get the 6 justices to all sign on to the reasoning? It's sort of an interesting thing, I think, to unpack, but it is a notable distinction from Dobbs, where much was made of the fact that the chief sort of lost the majority there for his approach in that case.
What do our other panelists think? You know, what survives of the Grutter and Gratz precedents, if anything? What do you think?
Well, I had a couple of questions about this case, and maybe Jen, you've thought about this. I wondered if the decision in the Students for Fair Admissions was in tension with the decision in 303 Creative, the other major constitutional case, or another major constitutional case that we saw this term, where it elevated the free speech right of a private party to discriminate in order to, for their expressive rights over a state interest in promoting equal treatment. And I wonder if there is a First Amendment element like that a private organization like Harvard College would have, and are the theories that go forward in 303 Creative about that right of expression and relatedly right of association in tension with the holding in Students for Fair Admission, which does not seem to recognize those kinds of rights to be exempted from an equal protection type of regime.
Well, I think that's an interesting connection to try to raise between the two cases, although I think, 303 Creative really in the end was about individual expression, and I think what the court seems to clearly be focused against in Students for Fair Admissions is the categorical approach. The one point that I didn't raise at the end is the chief does suggest that race could potentially still be a consideration if somebody talks about how their racial background has impacted particular other aspects of their character. Maybe going through adversity, through being mistreatment, has led to certain character traits or whatever. And so on that individual basis, that individual connection there, race can still be considered. And I think my inclination is that was probably put in partly to a response to some of the discussion that happened in oral argument, where some of the advocates were saying, well, we don't want race to be disfavored in a sense. Like if an applicant in their essay can mention every characteristic, we're going to be negative and discriminating against race as a separate characteristic if we don't allow folks to mention it. So it can be mentioned in an individual way, considered in an individual way. But we can't just raise up one group of people over another. And I don't think on that point there's much that I saw in the 303 Creative decision to be at odds with it, in particular since there's a lot made at the beginning of that opinion highlighting how the wedding website designer said she actually would serve people of all backgrounds. She just didn't want to be forced to be a mouthpiece for a particular message that was at odds with her convictions.
Cannon, since we brought up 303, would you mind giving us a rundown on that case?
Yeah, sure. So first of all, it's always great to be at the Heritage Foundation and always great to participate in this panel, though, as I think I've joked every single time since I've been here, I'm neither a scholar nor a scribe, so this should really be entitled Scholars, Scribes, and Some Random Lawyer Dude Review My Rulings. So
if you're some random lawyer dude,
well,
I don't know what I am. So
I am the token practicing lawyer on this panel. So 303 Creative is, a case that, at a very high level could be said to pit, the interests in free speech, First Amendment protected interests against the interests of LGBTQ individuals. But the question in the case really depends on how you sort of characterize what's actually going on. And so let me set out the facts as best I can. The case was brought by a Colorado woman, Lori Smith, who is a website designer, and she designs websites for weddings. And the question in the case is whether she has the right under the First Amendment to refuse to design a website for a same-sex wedding. And what's interesting about the case, and I think significant in some ways, is that it arises in the context of a pre-enforcement challenge. And what that essentially means is that she is suing preemptively. So this is not a situation where you have an actual same-sex couple who wanted to have a website designed and she denied them that opportunity. Instead, she's suing because she wants essentially to have the ability not to design a website. And Colorado has indicated that it would enforce its anti-discrimination laws, its public accommodation laws against her. And so the case comes to the Supreme Court, as we lawyers say, on stipulated facts, namely that her claimed injury here is that she would be likely to be asked to design such a website and wishes to have the right not to do so. And that becomes significant for a reason I'll come to in a minute. So the case comes up to the Supreme Court, and in one of those relatively rare 6-3 decisions where the justices divide on so-called partisan lines with the 6 Republican appointees in the majority, the court says that Ms. Smith indeed does have a First Amendment right to choose not to design the website for a same-sex wedding. This was thankfully one of the relatively few big cases where there were only 2 opinions, so you can actually print out the opinions in this case without refilling the printer paper tray. That was a rare quality this year in the big cases. And the majority opinion was written by Justice Gorsuch. The dissenting opinion was written by Justice Sotomayor. There's been a lot of speculation about why Justice Gorsuch, particularly in a term where it seems like virtually every majority opinion we're going to discuss was written by the Chief Justice. The Chief Justice exercised his prerogative to keep seemingly almost all of the big cases this term, but not this one. Now, notably, Justice Gorsuch was the author of the Bostock opinion, the case that recognized that Title VII prohibits discrimination against same-sex individuals. Maybe that was at the back of the Chief's mind when he decided to give Justice Gorsuch this opinion. But Justice Gorsuch, as is his wont, made this seem like a pretty straightforward application of First Amendment principles. He said that this is basically a case involving, first of all, expression and the expression of Ms. Smith, because any website has a certain amount of First Amendment protected content in the speech and design of the website. And therefore, when you're thinking about this in terms of First Amendment doctrine, this is really a case, in the majority's view, that involves a doctrine known as the compelled speech doctrine, a doctrine that basically says the government can't force you to engage in speech that you do not wish to engage in. And, ultimately, really, although there are 70 pages of opinion, so you still have to have a reasonably full paper tray on your printer, the case, I think, really boils down to, a couple of questions. First, whether or not you characterize this as a case involving speech and expression rather than conduct. And there's a vigorous back and forth between the majority and the dissent about that. Justice Sotomayor, in her dissent on behalf of the 3 Democratic appointees, says this is really a case where any speech, if there is speech, is incidental to conduct. It's the act of designing the website. And so this is a service provider. It's no different from, say, somebody who offers hotel rooms and then denies hotel rooms to someone who might have a constitutionally protected characteristic. And so that dispute, I think, looms really large in the case, because how you view the case constitutionally, I think, really depends on the answer to that question. And similarly, I think as a result, Justice Sotomayor, in her dissent from the very first paragraph, says, this is really about the denial of service to a class of individuals. And so it's really, in her view, again, not so much about the expression as it is about, sort of saying, there are these people who come, at least theoretically, to Ms. Smith and ask for her wedding website design services, and what she is basically doing is saying, I'm not going to provide those services to same-sex individuals, and therefore this is comparable to, the hotel operator, the paradigmatic hotel operator who refuses, for instance, to rent rooms to, say, an interracial couple. I think there are a couple of aspects of the case that are significant going forward. The first is that, you do have to have some degree of expression in order for the principle of 303 creative to kick in. And so where do the sort of outer bounds of that lie? When does a case truly tip into the category of involving only conduct? At least in the context of weddings, we've seen innumerable permutations of this issue. We've seen wedding photographers who bring similar claims. We've seen, of course, famously, a cake baker whose case came to the Supreme Court, which triggered, the somewhat bizarre scene of, whole amicus briefs devoted to the question of whether there is a First Amendment component to cake baking. And so that, I think, is question number one. And then question number two is that when the court took this case, it took pains to really grant review only on the question of free speech, and thus took the issue of religion out of the equation. So it really left for another day the question of whether the free exercise clause of the First Amendment could also provide similar or perhaps even greater protections to an individual or an entity seeking similar protection, and query whether in a case involving the free exercise clause the court might grant potentially even broader protection. That issue, I think, remains to be seen. There was one footnote before I subside about this case, which was, I think, literally the day before the opinion came out. There was a suggestion in the press that there was a fact in the case that might, in fact, have been in dispute, namely that in the record there was someone who, through Ms. Smith's website, claimed to be a same-sex individual seeking access to her services. And the report was that, in fact, the person who was named was not the person who made that submission, that a reporter, an enterprising reporter, contacted that person, and it turned out not to be the same person. It turned out that person wasn't even gay, that person was straight. I think that proved not to be significant for the simple reason that in a pre-enforcement challenge, whether or not there is in fact somebody who's being denied service is kind of neither here nor there. And interestingly, the majority opinions, I think, took pains to highlight other facts that it viewed as the stipulated facts, namely, Ms. Smith's desire not to provide provide her services to individuals who were seeking those services for same-sex weddings. And so, and even though that came out right before the opinion, there was, I think, no suggestion in the opinions themselves that was somehow a salient fact, but it was kind of an interesting sidebar to what took place.
Any responses from the panelists?
Well, I think it's interesting that religion wasn't a part of this technically, but it runs through the opinion. It's sort of at the heart of the opinion. And the way the court accepted the case, it seemed like the answer was going to be, almost definite, that we knew the way the case was going to turn out from that way. And I thought it was interesting, too, that the court had turned down, perhaps because of different mix of justices on the case, had turned down cases in which there was an actual conflict. A photographer who was asked to do a wedding, a florist who was asked to provide flowers for a wedding, and the court took this. And I think you're right, Cannon, that the stipulated facts in this really hurt Colorado as it tried to defend its actions.
Jess, would you like to talk about Sackett?
Well, sure. Sackett's an interesting case in many dimensions. This was a case that clarified the meaning of waters of the United States when it comes to the provisions of the Clean Water Act. And the case is familiar, certainly to Bob and to me, because we've encountered it several times over the years as it has come back and forth to the Supreme Court. The bottom line of the case was that the waters of the United States needed to be construed more narrowly than courts and the EPA have understood it to be to this point, in an opinion by Justice Alito. And interestingly enough, the case was a unanimous, I believe it was a unanimous case in the judgment, in that every justice of the court believed that in the particular permitting application for Priest Lake, Idaho, that the Sackett couple wanted, the government had gone too far. But in the concurring opinion by Justice Kagan, there's really no discussion of why she believes the government had gone too far in this case. It's really all about why she believes the majority went too far in explaining the new rule. But to explain what that rule is, Justice Alito, and it's I'm I'm the Justice Alito impersonator today because I believe the other case also was written by him that I'll be explaining. In contrast to his well-known opinions of the previous term, which had some provocative language in them, this opinion is quite moderate. It's really, in the sense, it says, this is a nagging question that has existed for many years about how to define this amorphous term, waters of the United States, and here is our extraordinarily reasonable resolution of that question. And he says that, in essence, to be covered by the Clean Water Act, a wetland, something that is not an actual lake or river or ocean, for a wetland to be covered by the Clean Water Act, it needs to be essentially indistinguishable from one of those navigable bodies or larger bodies of water. It has to be visibly connected to it. It has to be something that is really an appendage of that body of water. And this guidance applied to this property in Priest Lake, Idaho, and apparently will limit the scope of the act going further with projects that may have much greater environmental consequences than a single home site in this remote part of Idaho. So that is the clearer guidance. As we saw in some of the other cases involving federal regulation, certainly in the student loan case that I think Jen will be talking about later, you have the majority essentially saying, we can't believe that Congress would have intended to give authority this broad to an administrative agency. And since they haven't explicitly said they are, then it would be unreasonable to imply that they have. And the dissenters take the sort of mirror image and they say, the Congress did not deny them this authority. They used broad language. Who are we to read into it a restriction that the Congress chose not to place itself? And that's really the difference, the sort of other ends of the telescope that you see between the majority and the concurrence, to be technical, but what is, but for all practical purposes, a dissenting opinion. And this case, although it is even less relevant to the legal question than the point Cannon brought up about how manufactured the facts were, may or may not have been in the 303 case, but the Sackett case is it's a good example that plaintiffs in test cases aren't what they want to be, because I just remember over the years as I followed this case, oh, there's another Sackett development, and I look, oh, Sackett was arrested for sex trafficking. Oh, Sackett pleaded guilty to a reduced charge and went to jail, and so it just sort of struck me as kind of usually not relevant to the legal question in the case, but often when activist groups try to bring an issue and try to frame a case in a sympathetic way, they look for extraordinarily sympathetic plaintiffs, people have a great story to tell. This may not have been as great a story to tell, but it certainly does show that when the court is looking at this issue, they are, they're not acting on their personal views of the, party's conduct, but they're looking at the legal issue before it, because, and that's what we had in I'd say, the Sackett case.
I will return, after we talk about the student loan case, I'll return to and get some overarching thoughts about the state of administrative law and the relationship between the court and administrative agencies. But before then, Bob, can you talk about Moore versus Harper?
Sure. So you can tell who's the silver-tongued appellate lawyer and who's the law professor and who are the scribes, who need to type things out to make sure that they remember it. Moore v. Harper was about the independent state legislature theory and would have been a huge change in election law, that state legislatures have almost unlimited power to decide the rules of federal elections and draw congressional maps, even if they're extremely partisan, without any interference from state courts. And the case came from North Carolina, where Republican legislative leaders had said, we get to do this without interference, that this comes from the Constitution's Elections Clause, which says the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But 6 members of the court said that that was wrong. And the Chief Justice, as we've talked about, took the case for himself and wrote, the legislature acts both as a lawmaking body created and bound by its state constitution and as the entity assigned particular authority by the federal constitution. Both constitutions restrain the legislature's exercise of power. So he was joined by the liberal justices in this, and also Justice Kavanaugh. And this would have been, is one of those cases that would have been a big deal if it had gone the other way. And even as it was, it was a change because while the court said that they weren't buying the big independent state legislature theory, they were concerned about courts getting too involved in this. And so the Chief Justice added this caveat: although we conclude that the Elections Clause does not exempt state legislatures from the ordinary constraints imposed by state law, state courts do not have free rein. State courts may not transgress the ordinary bounds of judicial review such that they may arrogate to themselves the power vested in state legislatures to regulate federal elections. And he said, by transgress the ordinary bounds, what does that mean? They don't say. They say that these cases are complex and context specific, and that they will watch out for this, and they'll know it when they see it. The dissenting justices said that that was wrong. 3 of them, Justice Thomas, Alito, and Gorsuch, they said that the court shouldn't have heard this case, shouldn't have reached a decision, and those of us covering it every week kind of were expecting this case to be dismissed as moot, because after the North Carolina Supreme Court had said that this plan was unconstitutional under the state constitution and imposed its own plan, the election was held. The state elected Supreme Court switched from a Democratic majority to a Republican majority. They reheard the case, and this new majority on the court said, actually, we don't have any power to police partisan gerrymandering, and so we're going to go back to the old plan. So the 3 dissenters said that should have been the end of it for the Supreme Court. But then 2 of them, Thomas and Gorsuch, went beyond that, saying if we were going to reach it, that they did think that the independent state legislature theory had a lot to say about it. And they're very wary of federal courts getting involved. So, interesting reaction to this decision, I thought, from the voting rights activists and Democrats and liberals particularly, who were very worried about it. Some embraced it. Others said this just sets up federal courts to have more of a role in what has always been something left to state courts. The other side said, let's take a win when we get one from this court, and realize that we sort of got what we wanted, and that the bigger picture seemed to be 6 justices a little wary about challenges to some of these election cases that might be coming up in 2024.
Jen, student loans.
All right, just moving through here. So student loans came up in 2 separate cases, one with an individual, one coming up from the states. And so the court first examined standing, which is the doctrine that under the Article 3 Constitution, there's a limited judicial power. And so the court and federal judges are only supposed to be evaluating cases and controversies, which means that in every case for a federal court to have jurisdiction under the Constitution, there needs to actually be a real controversy. And so the court unanimously found there was no standing for the individual claimant because that individual was essentially saying So the statute under which the Biden administration purported to forgive student loans is called the HEROES Act, which, if the Biden administration's loan forgiveness plan had come within the confines of that act would have permitted the administration to act without going through full notice and comment rulemaking procedures, which normally requires agencies, to the extent we're going to talk about administrative law later, on substantive matters to give a certain comment period so the public can be involved and at least flag concerns with the draft rule before the rule is finalized and then published, to give some kind of notice and opportunity for public participation. That didn't happen here. The claim was that, from the individual, if the Biden administration had not thought it had authority to act under the HEROES Act, it would have instead operated differently. It would have given more procedures, which would have allowed the private parties to say, we are not adequately helped by your current rule, give us a different rule that will help us more. And since there was no real concrete financial injury to them based on the Biden administration's action, the court actually fairly readily, I think, dispelled the idea that there was standing there, and quickly moved on really to the decision in the next case. So in contrast to Harvard and USC, which were sort of argued on the same day as a pair but separately issued one decision, here the cases were again argued the same day, but the court issued two different decisions, refusing to do what would perhaps arguably have been an expansion of standing doctrine by hearing the individual claim. And so instead turned to the state case, and in that case found standing and then moved fairly quickly to the substantive issue. And I think this is actually, I mean, it was a 20-something page opinion which suggested that the court, even though it was a 6-3 ruling, did not feel it had to tie itself up in knots, that it was not a particularly close statutory case. It didn't come up with new interpretive principles or new interpretive doctrines. I think essentially it was a fairly, I'm sure folks will disagree, I'm going to make the case it was a fairly straightforward, ordinary meaning interpretation of a statute that said the secretary may waive or modify provisions related to financial assistance programs, essentially if it's necessary to keep folks from being in worse financial position due to a national emergency or hardship. So there were many aspects of that arguably modest statutory authority that the parties went after and said showed that there was no way that the Biden administration could forgive $430 billion of student loan debt for people having between $10,000 to $20,000 worth of loans being forgiven under that modest provision, which seemed to be oriented toward national emergencies that arguably were not tied really to the scope of the program or the timing of the program, perhaps. And that also waive or modify are a lot more modest than what was happening here, which was a major expansion of the program. Justice Barrett wrote an interesting concurring opinion, essentially clarifying that even though the major questions doctrine, which was talked about a lot last year in the West Virginia versus EPA decision, that it really wasn't essential to the court's decision here, that this was not about reading a statute differently if a question of economic and political significance is involved, that here ordinary meaning principles, regular across-the-board textualist principles would apply to find that the Biden administration had acted far beyond the scope of statutory authority here. So this case, I think, really is about the axis of, does Congress, when it puts forward a statute authorizing administrative or executive authority, does the executive have to stay within the confines of that? Or can the executive, after years go by, get how forward-leaning, how broadly can the executive branch read such statutory authority? Here, not only did it seem to be clearly beyond the bounds of the statutory authority, but there was also other color and context that suggested Congress had really not intended this broad of an action. The Secretary had not previously seen his or her authority under the HEROES Act to extend this far. Although one final thing, I mean, the Biden administration is not the only administration that did try to take student loan action. I mean, the Trump administration had also taken action to kind of put a pause on repayment that was not found found unlawful by a court. So here, perhaps the number of years later, going clearly a few steps further than the Trump administration had gone, this was challenged pretty readily, and the court reached, I think, a resounding decision against the Biden administration here.
Jess, Bob, do you have any reactions to that? We haven't come at this from a different perspective.
Well, I wonder, Jen, why I think the Chief did go to the major questions in this opinion when they said that it wasn't needed, that, it was clear from the statute, and then he sort of threw it in again. And, Justice Kagan in her dissent said, whenever this court wants to do something now, it just throws up the major questions doctrine. And I wondered why he sort of gave her that opening.
Well, I mean, it's hard to know the minds of justices, but I think one reason might be that he obviously, having, written about the doctrine previously, doesn't think of it as a negative doctrine, thinks of it as more legitimate. My guess would be, if I had to guess, but obviously I have some sort of interpretive priors that are influencing this. I sort of perceive the Chief, particularly in his chief role, as always taking whatever steps he feels like he can or wants to or are needed to sort of dial back the significance of an opinion. And to the extent that this opinion brings in major questions, it keeps folks from spending perhaps as much time talking about what's coming down the pike next. Also, I don't actually think he believes it is an entirely new doctrine put into place by West Virginia versus EPA last term. And I think it seems to me, and maybe Cannon or you all have different views, but that he is one who, in a more pragmatic sense, likes to sort of give alternatives or talk about all the tools in the toolbox to help in a particular case. But I share your the general cynicism or idea that, yes, I think to the extent that we're in a discussion about major questions, it is a tool that the court will apply when it thinks it's helpful and useful. The Chief thought it was at least helpful to make a fig leaf to it here. But I don't think he perceives it as being outside the bounds entirely of textualism.
Jess, Cannon, any thoughts on those cases?
Well, I think it was interesting that the Chief Justice, in addition to looking at this aspect of the HEROES Act or whatever, mentioned a broader concern about the way that administrative agencies have been acting. And so it seemed that he was, as if it weren't already evident, signaling a philosophical or a broader jurisprudential view about the bounds of the executive's autonomy to apply statutes. So he didn't leave it just at student loans. He said there's a pattern here, and I wonder if that's a message to the administration, or what. Who is he talking to? Obviously, to the extent he was talking to the dissenters, they did not find that persuasive, since they specifically said, there you go, you just don't like policy, and therefore your made-up doctrine is striking it down. So it didn't work with them. Who is he talking to when he brings in those broader concerns that are not directly related to statutory interpretation of this student loan relief plan?
Cannon, any thoughts on that case?
I think the Chief Justice was speaking to the lower courts. We've now had 2 opinions in 2 years that have relied expressly on this major questions doctrine. And perhaps not coincidentally, that's occurring at a time when we have an administration that is in the process of deciding some enormously consequential issues through rulemaking. And those rules are inevitably going to be challenged. Spoiler alert, they're inevitably going to be challenged in part based on the major questions doctrine. And lower courts, in short order, are going to have to grapple with those arguments. And so, I think in some sense, my own reaction to this opinion was that the reliance on the major questions doctrine was intended to put a little bit more by way of meat on the bones on this doctrine, which, as Jen says, both has a footing in administrative law that goes back, I think, some distance, but also is a relatively new thing in terms of its express denomination as a discrete doctrine. And there's a really fascinating concurring opinion from Justice Barrett that I think lays out the conceptual groundwork for this doctrine in a very interesting way.
I was hoping Cannon was going to explain standing, because I've only covered the court since 2006, and I still don't understand who has standing and who doesn't. Do you?
Particularly in cases involving states, I think it's fair to say that the doctrine appears to be evolving.
It always is. Would you like to talk about Allen versus Milligan?
Sure. So I think this is an interesting case because in some sense I think it just defies the narrative that the conservative side of the court achieves quote-unquote conservative results in every single case. And, as was true with Moore versus Harper, there's sort of an interesting debate about how significant this is between those who actually litigate the cases and those who want to characterize the court as moving in a particular direction. This is a case involving Section 2 of the Voting Rights Act, and I'm going to resist the urge to get too far down into the weeds of how voting rights law operates because it can get very complicated very quickly. But the basic gist of Section 2 of the Voting Rights Act is that, as amended by Congress, which becomes significant, it prohibits voting practices that have either a discriminatory intent or a discriminatory effect, which includes practices that dilute the strength of votes of racial minority voters. And that becomes significant in this context, in the context of redistricting. So this case involves a challenge to Alabama's redistricting plan, which was a plan adopted, I think in the wake of the 2020 census that would have created only one African-American majority district, despite the fact that black voters make up, I believe, 27% of the population of the voting age population of the state of Alabama. And this was immediately challenged, and as the case came to the Supreme Court, a three-judge court had concluded that the map likely violated Section 2 of the Voting Rights Act because of the way that voting rights law operates. These cases basically go from a three-judge panel directly to the Supreme Court, and the court heard oral argument in October. And in yet another of the opinions written by the Chief Justice, but this time with a 5-4 majority that consisted of the Chief Justice, Justice Kavanaugh, and the court's 3 Democratic appointees, the court agreed with the lower court and therefore with the challengers that there was likely a violation of Section 2 of the Voting Rights Act here. And the case involves the application of the so-called jingles factors. Again, I'm going to resist getting into these factors, but these are the factors that are basically used to evaluate claims that are brought under Section 2 of the Voting Rights Act. But I think that the sort of perhaps most critical part of the opinion is that in analyzing maps for redistricting, what courts do is to basically compare the maps against a benchmark. And the state of Alabama made the argument that if you could come up with a race-neutral benchmark, and if the map that was prepared compares favorably to that benchmark, it's okay. That would have worked a revision to Section 2 of the Voting Rights Act, and the majority rejected that revision, rejected the argument that a race-neutral benchmark should be used in the analysis. And interestingly, the Chief Justice, in his opinion, talked at great length about how when Congress amended the Voting Rights Act, it intended Section 2 to operate quite expansively. What's really interesting about that is that the Chief Justice, at the time that Congress amended the law, was working in the Reagan White House and was very involved in these issues. And what Congress essentially did in the 1982 amendments was to essentially overrule a Supreme Court decision that limited the applicability of Section 2 to practices that had a discriminatory intent without a discriminatory, that had a discriminatory effect without a discriminatory intent. And in this case, the 4 other Republican appointees dissented, both Justice Thomas and Justice Alito, and in particular, they sort of emphasized the fact that the effect of essentially requiring the state of Alabama to draw a map that took greater account of the number of African American voters, and in particular, potentially requiring them to draw a map that would require 2 districts that were majority black districts, would be to force the drawing of district lines based on race, the suggestion being that that could itself raise constitutional concerns.
Before I turn over to audience questions, any overarching thoughts about the term, themes you want to pick out, things you want to talk about in terms of it being Justice Jackson's first term, maybe how the court has changed? I leave it to you.
Well, starting with the Allen v. Milligan case, that Ken did a great job explaining. I think that if I would think about it, one of the broad takeaways, you could look at Allen v. Milligan and Moore v. Harper, which Bob explained for us, that this is a very conservative court, but you can't say it is a partisan Republican court that acts uniformly in the immediate political interests of the Republican Party, because whatever nuances or reservations there might be for those two decisions, the immediate effect of both of those cases is to deny an electoral advantage that Republican Party was seeking for the 2024 election. So it certainly doesn't take away from the court's overall trajectory to the right, but it does, I think, belie arguments that it is purely an arm of the Republican Party in what it's deciding. And also, I thought, the Chief Justice was, redeeming some markers he put out in the past. I mean, in Shelby County a decade ago, where he wrote the opinion that removed the coverage formula for preclearance under the Voting Rights Act, essentially eliminating a major tool that the Justice Department had to protect minority voting rights. He said that Section 2, the substantive provision of the Voting Rights Act, remains in force, and that will be sufficient to protect any residual matters that might arise, even though we're no longer in 1965 and things are much better in terms of race relations. Well, in this decision in Allen v. Milligan was essentially redeeming that promise that he left out there. Well, we're going to continue to enforce Section 2 just like I said we would 10 years ago. And the tone of the opinion was very different. I mean, he explicitly referenced history of racially polarized voting in Alabama, while in Shelby County he was like, black voting participation in Alabama is higher than ever. It's higher than white voting out. What's the problem? So there was a difference in tone there, and a suggestion that he remains aware or has become aware of some criticisms that are out there. And likewise in Moore v. Harper, when the court ultimately declined to find a remedy for partisan gerrymanders under the federal Constitution, the Chief Justice put out a laundry list of other potential remedies that, if this is really a problem, might be there. One of them he mentioned was state law and state constitutions. And in the Moore v. Harper case, again, he's saying, I meant it. We're not going to interfere with other mechanisms within the federal system that could address these issues if they arise. So those are some thoughts.
Bob, thoughts?
Well, I think Justice Jackson really established herself very quickly in a way I haven't seen from other newcomers to the court. Maybe Justice Gorsuch jumped in fast, too. He only had a little bit of the term left when he was there. But, she spoke more than any other justice, according to people who keep track of how many words the justices say. She asked more questions than other justices. She wrote solo dissents more than any other justice on the court now did in their first term. I thought there was one very interesting instance where I won't try to describe this case to you because it's just too complicated, but a criminal case in which she wrote a 39-page dissent to the majority, and Justices Sotomayor and Kagan together wrote a 2-page dissent. So they didn't join her and wrote their own, and I thought that was interesting since they were all on the same side. But I think that she is really sort of establishing her view of the law and writing for herself a lot in a way that I think is very different for a rookie.
Cannon, and then last word to Jen.
Sure. So I would just sort of offer 3 very quick headlines. The first is that I think that the court is perhaps moving more incrementally than critics of the court would have one believe. And I think in some sense this term represented a reversion to the court's ordinary way of doing business with a much greater degree of unanimity, much less consistency in the alignment of justices, as Jen pointed out. And, of course, a lot of that depends on what the court has on its docket at any particular time. But, this seemed like a somewhat less polarized term, even though in some of the highest profile cases you did have the justices sort of perhaps breaking down on more predictable lines. I think the second headline I would offer is that I think that the reports of the Chief Justice's demise were greatly premature. The Chief Justice played a really central role this term in, I think, shaping not only how the court decided cases, but kind of the contours of the legal rules in a lot of the key cases. And again, he wrote the opinions in a lot of the biggest cases, and I think a lot of those opinions, I think, reflected a high degree of judicial craft. This was a year that I think was really kind of the year of the Chief Justice in many ways. And then the third observation I would make, and I think that this is really kind of going forward a critical thing to keep an eye on, is that the 6 Republican appointees on the court are much less monolithic in their jurisprudential approach than the 3 Democratic appointees. And I don't mean that as a criticism of either side. It's just an observation. The 3 Democratic appointees, voted together in, I think, something like 88% of the court's cases. The number was much lower for the Republican appointees. And I think that reflects the fact that there are some meaningful jurisprudential differences. I would say that the Chief Justice and Justice Kavanaugh are probably the 2 most pragmatic members of the court, and they seem to define, what consists today of as the center of the court. It may be a different center from the center 5 or 10 years ago, but they seem to be the justices who are most likely to dictate the outcome in close cases. Justice Gorsuch, by contrast, is a somewhat more idiosyncratic voice on the court in certain areas of law, like Indian law and criminal law. He tends to vote with the more liberal members of the court, and indeed does so, I think, quite consistently. And then, you've got Justice Barrett, who I think is emerging as one of the most impressive voices on the current court, both in terms of her writing and in terms of kind of offering a thoughtful perspective that perhaps melds a certain degree of Midwestern pragmatism with some really incisive constitutional analysis. And then Justices Thomas and Alito, who are what they are, I think, probably the least deferential to precedent, and probably the most sort of consistently conservative members of the court. And those differences have really come into play in the cases where the court doesn't break down on predictable lines. And so I think the thing to watch going forward is the extent to which that continues to be true.
Jen?
Yeah, I agree with a lot of that, and just consistent with what I mentioned at the beginning, just in terms of the justices and which ones were most frequently and least frequently in the majority. I mean, Justice Thomas in the majority 76% of the time, the Chief and Kavanaugh together in the majority 95 and 96% of the time. One, I think, remarkable thing about that actually overall is that the justice least frequently in the majority was still in the majority 76% of the time. So that really does suggest that we spend a disproportionate time focusing on the cases that seem to be divided. There are a lot of unanimous judgments. And, as Cannon said, the Chief and Justice Kavanaugh are in the majority more than the others. But one final thing, I mean, when the Chief takes these opinions and writes them, it does allow for his more pragmatic or moderate sense to frame the decision. But I do think, and again, we'll never know because we can't peel back the curtain, and who knows, I'm forgetting which justices have restrictions on which of their papers will eventually come out. So some decades from now, we'll be able to get some of the writings, I imagine, that went into different opinion drafts, for example, leading to the final decision here with Students for Fair Admissions. But in a case like that, where you have an originalist justice like Justice Thomas, who also has really thought a lot about these issues, and then a more pragmatic person like the Chief, both signing on to the same lead opinion in full, I would really imagine that there was a real desire by at least some of those 6 justices to make sure that there was one unified opinion, and almost certainly some negotiating or discussion about the contours of the language and how things were going to be couched that would allow a very originalist, pure in theory justice and folks who are much more concerned with continuity of the past to all be able to come together around every single word in a decision of great significance. So all that to say, there actually is a lot of hidden power or more subtle power sometimes in the theorist on the court, because in the drafting and in the concurrences that maybe they would have written otherwise and decide to hold back, there can often be a lot of influence on the scope and the reasoning that ends up coming through in the final majority opinion in ways that might have great significance.
Well, let me open it up now to audience questions. A mic will be coming. Let me give you a warning. This is not your opportunity to lecture. You get 2 sentences, and then I cut your mic. I will not be gracious. So go ahead, Dennis.
Dennis Kirk. I'm wondering if you're reading anything into that administrative state being looked at closer by the court in the Chevron doctrine, where the court's deferences to the agencies might be reduced.
Yes. Yes, we have a case coming up that looks more directly at the Chevron doctrine, and I have to say that I think that there must be civil procedure professors everywhere so amazed and gratified that so many people talk about something called the Chevron doctrine. Yeah, absolutely. That was a rule that the court adopted in the 80s. Suggesting that when regulations are ambiguous or legal statutes are ambiguous, the so-called expert agency should receive deference from the courts in applying the statutes that it's been assigned to implement. And obviously, we see a lot of skepticism on this court toward the judgment of these agencies and whether that kind of deference is remains warranted. So I think we'll continue to see doctrine emerging that may be reducing that type of deference going forward.
Here in the front.
Leon Peace. And I had a question about the, in the past, the court has worked very hard to maintain the outward appearance of intramural collegiality. Those of us who were in the court during the last, delivering the last rulings, got the sense that from the body language, there might be certain level of tension in the intramural workings of the, with respect to the justices. What sense do you get in terms of the general camaraderie, or lack thereof, within this court?
Well, Cannon, you stood up there in front of them not too long ago, so what do you think?
I mean, they had a certain degree of discord toward me, because the last time I appeared in front of them, I got fewer than 5 votes. I'll leave it at that. I think that's a really hard thing for those of us on the outside to judge, because I do think that the court has long not only viewed it as important to be perceived as having that degree of camaraderie. I think the court really tries to achieve that camaraderie, because I just think from my own experience, they're all there for life. They know they have to hang out together, and so they have powerful incentives to try to get along on a personal level. I think it's interesting, we all read the tea leaves. You've alluded to one type of tea leaf, which is, how do they react when they're reading out the opinions, and I've certainly read, the same press reports, including by these gentlemen, that suggest that sometimes, it does seem like passions are running high, as you would expect, given the stakes. I think one thing that's interesting to me is that I think that the rhetoric in the opinions has gotten a little bit turned up. I don't know to what extent that's attributable to relationships between the justices. I mean, perhaps the most fiery exchange this year was between, of all people, Justice Sotomayor and Justice Kagan, which I think reflects that sometimes that happens sort of without regard to broader jurisprudential bents. But I also wonder to what extent that may just be due to the fact that it feels like opinion writing has gotten more informal. And I think when you write more informally, sometimes it comes across as sharper than if you're writing in a more academic style. And I think we have a number of members of the court who write, either informally or in a fairly accessible way. And so maybe that's one of the reasons we think that.
I thought there were 2 things interesting. One, the Chief Justice at an event in May said that every time he walks down the hall, he's happy to see one of his colleagues and engage in conversation with them. And then he said, but sometimes I don't walk down the halls. And so I think that's one answer to your question. And then I thought, it was pretty extraordinary in the student debt case in which the Chief Justice wrote, there is becoming a trend on this court for dissenters to say that we have exceeded our role, and he wanted the public to know that wasn't true and that they're not disparaging each other. And then Justice Kagan came back and said, well, yeah, we are kind of, because, it's always been that justices are supposed to point out when they think that the court has exceeded its role, and it would be wrong not to. You sort of got the idea, like which one, got their hands on it before it went to the printer to have the last word there. And so I think that does show that there's something going on between those two sides.
Did I miss anyone on this side? Yes, in the very back.
Sorry. Well, I'd like only to thank. I come from Brazil, and I want a support from you. We're going to vote the abortion next August, maybe. And I signed up the amicus curiae for Mississippi with 141 scholars from United
Did you
States.
have a question for these panelists?
No, I just want, if you can, I can share with you our amicus curiae for scholars
maybe
from
afterwards,
here.
but
And
for
then
now,
I wanted to
their
say that
expertise is here
I'd like
to talk about the Supreme Court. Yes.
I've heard of a Michigan law that purports a heavy fine if you address someone with the wrong pronoun. Wouldn't that fall in the same case as Colorado, where it is now the state coercing speech?
It's the first I've heard of it. I'm not familiar with the law.
There's one last question here in the middle.
Oh, I'm Peter Humphrey. I'm an intelligence analyst and a former diplomat. The question I have is, if ultimately a plaintiff doesn't have all the power in these free speech cases, because if the court were to rule against the free speech, the plaintiff can simply say, okay, I'm giving severance pay to my boys on Monday and I'm out of business on Tuesday. And could a really woke court then come back to the businessman and say, oh, no, you're not. You're staying in business one more week to make the cake or finish the website?
I think there's some war powers cases where the government can, take over properties, like to make sure that, national defense materials are available and so on. But I'm not aware of any cases where the government has done that sort of thing. Are you?
I know, and I don't think that Colorado would construe its anti-discrimination laws that way. But I will emphasize one thing that I said in my remarks on 303 Creative, which is that I do think that the pre-enforcement context of these lawsuits inherently makes them somewhat more theoretical, because what you have to establish in order to bring one of these lawsuits is just the likelihood of enforcement rather than the reality of it.
Well, we are out of time. Please join me in thanking our panelists.